I lived in that city for a number of years and often used that postal service.
Do you know the status?
Yeah.
You know that? Counsel.
Yeah, I have a law school classmate who used to be the deputy city attorney down there, and she called me a couple of weeks ago to get our pleadings. The building is for sale. I think there have been 4 or 5 different offers on it. One from the city. Of course, the hottest real estate in the United States right now. Hottest real estate in the world used to be Tokyo. I now think it's Palo Alto. Interestingly, there is a bill in Congress that will go nowhere because no bill goes anywhere in Congress these days, to require the Postal Service to give right of first refusal to the city in which the building is located if it's offered for sale. So that's the status of things in Palo Alto right now. I think the Postal Service has those offers under submission.
Brian, did you have some more things you were going to share about some issues that
Oh. No, it's okay. Let's just get to questions. Make sure we.
Okay.
You know,
So can they sell the post office before the court decision, before the suit goes to court?
Real easy answer, no. We exacted from them a 45-day notice. Yeah, 45-day notice. And in being willing to say no, we don't need to have a hearing on the preliminary injunction. The U.S. attorneys recognized that they had to give assurance. So we have a 45-day notice period, which is enough to get a motion heard on regular calendar in the federal court.
So this one's, let's put this one to Brian. Does the derelict Ukiah Post Office have a covenant, and is it on the National Register? Who holds the covenant?
Okay, yes, it's on the National Register. No, there's not a covenant that's been put on the building. And actually, that case was a real, I think it was a real wake-up call for a lot of people, because when you look at it, you know, after the fact, after the transfer, everybody realized, how did this happen? And there wasn't a group that was in play. I mean, I think a lot of citizens were upset, and some of you all may know more. Speak up if you do, but citizens were upset that nobody did a legal challenge. I still think that had they challenged them legally, they could have enjoyed the sale.
And to the same effect, the Stanford folks might have had better luck if they had gotten involved in the process a lot sooner. I mean, Stanford was kind of difficult. Now, Gray mentioned that case. The standing decision there is totally wrong. But the building has been sold, and so that creates a problem there. But let's just say the strength of our case is that we got in time, and because of your vigilance, really.
Great.
And Gray had something in the back. Gray, can you stand up so everyone can hear you? You had to follow up on that.
There was actually, there was tremendous community opposition to the sale of the Ukiah Post Office. There were 5,000 people signed a petition to save that post office. When you consider the population of Ukiah, that's impressive. It didn't do any good. And also the Postal Service removed the mural from the Postal Service, from the building, and for restoration in Chicago, and they have said they will return it if the city posts a $100,000 insurance policy to protect the mural. So it's completely up in the air at this time. And as you said, the building is just standing derelict.
And that's a shame. Some people have asked a couple of other questions about preserving other. Here's a question. Can we preserve Berkeley Post Office like they saved Grand Central Station? And the second part of the question is the Planning Commission coming up with a list of public uses for the Berkeley Post Office? And why can't we insist on public uses?
I'll just note that the Grand Central case was a really landmark Supreme Court case, which I like to say is the reason I have a job. Basically, it upheld the authority for cities to regulate for historic preservation, that it's a valid goal of local government. And so that really has lended a lot of credibility to the whole system of regulation that we have around protecting historic properties. So, yes.
And the second question, as you know, the Planning Commission, Council Member Arguin proposed a rezoning that was kind of going nowhere until it then got on the ballot as an initiative. And then the council, the mayor decided, well, maybe we ought to do the rare thing and actually enact this thing ourselves. And, we kind of held our breath for a while, thinking that, I won the bet. I had a bet with the mayor. He thought they'd sue on that under state law. So I should remember that. The mayor owes me dinner at Kamal. Next time you see him, remind him of that. Because I didn't think. I thought as dull as they are, they would not have the political ignorance to sue the city of Berkeley over its own ordinance. The post office has an interesting conundrum. If they sell that building, once it comes out of federal ownership, then it's subject plenary authority, city of Berkeley. Landmarks law applies. Zoning applies. As you know, the zoning pretty much prohibits, quote, private uses. Museum might qualify, but it's essentially designed to preserve the integrity of civic uses in the civic center. And so, any owner who buys the building has to recognize that it comes with that burden. So, they still could decide, maybe we'll just keep this building.
So let's do two at once because these are kind of interrelated. One, will the National Post Office Collaborate public trust argument be part of the case on behalf of Berkeley's post office? I gather that the Collaborate is not a party to the suit, even though they would have standing. And for Brian, what are the differences between the National Trust suit and Berkeley's lawsuit?
Okay. Public trust.
Yeah. I'm the one who used the words public trust in that meeting that we had in Brian's office, 2 or 3 years ago. And it worked at Mono Lake because Mono Lake is a body of navigable water that was navigable at the moment of California statehood. And so therefore, under federal doctrine, that land underneath Mono Lake is the property of the state of California, and California can decide what its public trust will be. And the Supreme Court, just to have a little water law lesson here, Supreme Court in the Mono Lake case said the public trust at Mono Lake includes preserving the ecological stability of the lake, and therefore the state has the prerogative to reassess giving permits to Los Angeles and modifying those permits to ensure that the lake will remain ecologically stable. The post office is a federal facility. Federal public trust law is a very undeveloped area. My late colleague, someone that probably many of you know of, whom we all worship as the father of the modern public trust doctrine, Professor Joe Sachs, wrote a wonderful book called Playing Darts with the Rembrandt. And his thesis was, can the state prevent the private owner of a Rembrandt from playing darts with it? Is there a public trust in art? And his classic example is if the government tried to sell Independence Hall, could we stop that? So that's the extreme. It's a doctrine waiting to get developed. In my judgment, it's not one that we would want to hang our case on. And I think the Collaborate found that that was their first claim that was dismissed. But the way we've worded our complaint, and Brian, I can't remember whether you picked up on that language in yours or not, but we did use the words public trust to define just the duty of the government, that the nature of the resource that the government holds. But, we've got two legal theories that are well established with, dozens, hundreds of cases in the courts in the last 50 years that have used those laws to stop what we're trying to stop. I would like to see a federal public trust developed. I might wait for a different Supreme Court, however.
As far as the differences between our cases, we thought strategically about this. We're in very close coordination, obviously, with Zach and Tony. And I work, as he mentioned, with Betsy Merritt, she's been doing preservation law for a long time and is a fantastic attorney. So We really saw a lot of advantage in filing a separate action because we would have independent rights. We were particularly interested to see if they would challenge the standing because I don't think anybody questions that the city and the city council members would have standing, but we as a nonprofit public interest group, much like the Collaborate, had we been challenged on that issue, we wanted to make the law to say, of course, we can challenge these laws. That didn't happen, and we're actually really grateful and maybe a little surprised that they didn't raise that claim in the motion to dismiss. And so largely we're in the same boat, making similar arguments. We're fortunate the briefing schedule was about a week off, so as Tony mentioned, the city filed last Thursday and we filed today, so we had another week to just read their brief and then find some other cases. So in a way we get 2 bites at the apple.
So we have 3 more questions, and actually I have one. So the standard law school concept of mootness, this is still capable of repetition yet evading review, because Richard Blum and the real estate company still has it on their website, right? Yeah. It's still up for sale.
No, it's not listed
for
sale.
Oh, it's not listed. They took the listing off.
That was a very cosmetic thing they did.
Exterior looks like it's not for sale, but reality it really is, right? It's still on the market. So if the main office is not sold, has moving the carrier operation back into the location been considered as an option? Do you know anything about that? Either of you have that knowledge? And sadly, some of the services have been stripped away, as you know, like San Pablo. Anybody have the downtown post office? Is their post office? I do. So if you get a package now, you have to go down to, you have to do that, Sally, is go down to San Pablo. I've lost packages as a result because I never have time to go down there during the week. I don't have a car and I work during the day.
Yeah, that's part of the city's position, that any resolution of this should not just keep the post office open, but restore those services. I mean, admittedly, the distribution, if it's just getting the mail from Oakland or whatever the Northern California depot is, and distributing it to carriers, I can see doing that down on San Pablo. But in terms of customer service, this should be the premier place. And that's very much the city's position, that those services should be restored. Before the Collaborate case, there were 2 or 3 other cases, I think brought in the Virginia-Washington area to try to stop the sale of post offices. And they focused on what one might call the service, that the managerial aspect of how the post office does its business. In those cases, the courts ruled that the Postal Reorganization Act says the courts cannot review that sort of internal management. And I think the Postal Service thought, and still argues in our cases, that exempts them from any responsibility to the outside world under federal law. Ninth Circuit has already ruled against that claim in another case. So that's why we're not challenging that as part of our lawsuit, but it is definitely part of the City of Berkeley's platform.
No.
So, have you entertained individual plaintiffs to be part of having standing? I'm a customer, you're a customer, many of us are customers. Have you thought of taking on plaintiffs to join the lawsuit as indispensable parties because we're affected?
Well, we have a membership, so technically I'm here representing all of the 750,000 National Trust members because the issues that we're focused on kind of pertain to that, who we're able to basically speak for. So it's an independent lawsuit at this point.
I'll give a more honest answer from Berkeley's perspective. I mean, I got to represent my council and my city here. What was the phrase that I once heard, that keeping law professors in line is like herding cats? And the answer was no, it's like herding lions. Trying to manage the citizenry of Berkeley is like herding tigers. I mean, as a lawyer, I want to have one client or a few clients to deal with who can make decisions. I mean, this is a very honest answer of why you don't want too many people in a lawsuit. That's a strictly practitioner's perspective.